It's been more than 4 years since voters approved adding language to the state constitution affirming New Yorkers' rights to clean air, clean water, and a healthful environment. And in the ensuing years, we've seen a number of court cases testing how the constitutional amendment impacts real-world decisions. Repeatedly, and again with a mid-level appeals court ruling a few weeks ago, judges have limited the applicability of the constitutional guarantee, including rejecting the idea that imposes environmental standards above and beyond what might already be in place and being enforced. For more on the latest case and what this all means for the amendment's applicability moving forward, we're joined on the Capitol Press Room by Tom Berkman, a partner with the law firm Hodgson Russ, who previously served as general counsel for the State Department of Environmental Conservation. Thanks for visiting us in the studio, Tom.
Well, thanks for having me.
So as I mentioned at the top, you were working in state government when this amendment was moving through the legislature and then overwhelmingly approved by the voters. But as we mentioned before we started recording, this is just 13 words that were added to the state constitution. So what was your expectation at the time of what this would mean in terms of implementation?
You're absolutely right that the simplicity is certainly elegant, but it did create a high level of ambiguity. I think it was unclear as to what to expect from it. In many ways, it was tailored after other green amendments in other states. Some of those had some additional hooks to them versus this one, as you said, it was 13 words. So some of the unanswered questions when that came out was, is this self-executing? Meaning, do we need any sort of legislation to create causes of action in addition to this particular amendment? Who's subject to it? Who can use it? Is it subject to private parties, subject to the state? Who ultimately bears sort of the brunt of ensuring that this constitutional amendment is enacted? And then there's that question of what is the standard? Not only sort of a standard from a judicial review, is it strict scrutiny under sort of constitutional provisions, but also does it create additional substantive rights? And I think that's probably the biggest question. In addition to already what is a robust sort of environmental law that the state has, what does this constitutional amendment add to that? Is it providing something in addition to all of those, laws, whether it's clean water, clean air, climate, solid waste, all of those? Is there something that brings it to another level, so to speak? And I think we're starting to get some of those answers through the court cases, and there's been a number of these, right? Invoking the Green Amendment. These challenges have come from challenging landfills, shale mining operations and aggregate right here in the capital region with Norlight. But there's also been challenges for not fluorinating water, for congestion pricing, challenges just for revising a park.
And to be clear, these challenges have come from, say, private organizations or individuals who are looking to compel action. Essentially, these are groups that feel like the status quo or existing efforts to regulate or enforce aren't going far enough, and they're basically reading the amendment, this is at least my understanding, to say, hey, we think this amendment sets up a new standard, that it sets up a guarantee of some sort of right, and the courts have found, no, you don't necessarily have the right to go after those changes that you're looking for. Is that a fair description? I mean, how would you describe the rulings today?
Yeah, I think that is a fair description. I think you're absolutely right. These are these individual groups that are seeking to have another hook into litigation, right? Because there are existing laws. There's always been Article 78. So it's not as though there haven't been environmental challenges to state actions in the past, but this is, I think, viewed as an additional hook and an ability to maybe move the needle. And they have been very specific in requesting that the court direct specific action, right? That the court step in and not only find that, yes, failure to do X is a violation of the Green Amendment, but we are now directing the department or whatever agency that may be, to take a specific action. And that's ultimately where the courts have been really hesitant to go. I think courts in general don't view themselves as creating new substantive rights. So where you have these litigants who are asking for, we want a different standard applied here, or we want something more than what the ECL already, and that's the Environmental Conservation Law, already requires. Courts have really sort of been hesitant to do that.
Right.
I think we've seen that in a number of cases. But at the same time, I think you'll see in some of the dicta that it's not that the Green Amendment, has no meaning. They're just really hesitant to apply it to any of these cases.
Well, yeah, let's talk about this most recent one involving the shale quarry mining operation that you referenced earlier, overseen by the company Norlite in the Capital Region. It's facing litigation from the state, but we had these interveners who basically said, we'd like the court to take XYZ steps, and the court said, no, thank you. This is something where the DEC has an extensive history of regulations, multiple notices of violations, and therefore we let this play out. I mean, how should we think about that?
Well, I think that's right. This may not have been the best case to bring a Green Amendment claim, because after all, as you pointed out, the litigation started with the department seeking to put an injunction upon Norlite for some of those actions. So you're right that these interveners said that's simply not sufficient. We're looking for more. The facility cannot operate consistently with the Green Amendment. We want the court to direct them to essentially revoke that permit. The court did a couple things, I think, in its ruling, which reinforced an earlier ruling from the Fourth Department that dealt with a landfill litigation. One, they did affirm that you can't bring an action against specifically a private party. They talked about that in the dicta, right? So that was something that was previously decided, that the constitutional amendment does not allow a private citizen to bring an action against a private entity or a private person, that it really was for the state. But they did, and used pretty strong language that it did not create a self-executing substantive right. So while maybe not contesting the idea that it is self-executing, what it didn't do was create these additional rights. And the other thing that the court did that I think was really important, that really is going to limit sort of how the Green Amendment can be utilized, is that it reaffirmed that earlier decision that mandamus, that essentially by asking them to have the department do something specific, that action really doesn't apply to discretionary actions, right? And enforcement, by its very nature, is a discretionary choice. How you enforce, when you enforce, who you enforce against, those are all sort of discretionary determinations. And the court found that, no, you cannot force an action that is discretionary. So the Green Amendment doesn't somehow change that analysis that's already sort of in the law. So that was really sort of an important component of that decision. And I think in the future that really limits the scope of how that Green Amendment can be utilized.
Well, what about what the Green Amendment means for the powers of various state agencies like the DEC or other entities that might have oversight of some sort of environmental activities? Is there a world in which they could potentially cite the Green Amendment for their powers to regulate something above and beyond maybe what even state law might already allow them to do?
So I think that's an interesting question, and I think it's unanswered. We haven't necessarily seen that applied explicitly in any decision making. We have seen Section 7.2 of the CLCPA applied in some decision making. It has similar kind of language as to one has to consider sort of whether an action is consistent or inconsistent with the goals set forth in that, and it's sort of an open-ended provision as well. So we have seen that applied there, but I don't, to my knowledge, I haven't seen the Green Amendment directly applied.
Could you imagine regulators using that as opposed to waiting for statutory language to take action?
I think it really depends upon sort of what the department or the regulator or whatever agency is facing. I mean, when this particular Green Amendment was passed, it was sort of in the heels of the Hoosick Falls scenario where you had these unregulated emerging contaminants, and sort of what direction ultimately should the state be able to take. So I think there may be opportunities in the future where there are these sort of emerging environmental impacts that potentially haven't been directly legislated on, and whether the department or any department, I keep saying the department, but any department
Sure.
wants to sort of utilize this Green Amendment to say, hey, in addition to the regulatory requirements, we're going to go in this direction. But I will say, New York State has this robust sort of environmental law, in the books. And really what we're talking about a little bit is already embodied in SEQR, right? SEQR, ultimately, you're making sort of those determinations on a project on a whole, both from a regulatory standpoint, but from a broader sort of environmental standpoint, and making determinations whether there needs to be additional mitigation, whether there needs to be avoidance, what are the economic benefits, and sort of weighing all of those things. That's where I think it becomes really difficult to understand where this Green Amendment fits in, because of all of those things that are already in place here in New York.
Well, you mentioned SEQR, the State Environmental Quality Review Act, which the governor is looking to limit in terms of its application. And I wonder whether something like that, or maybe a reversal on a decision on a permit that might have previously been denied and then now it's approved, or maybe regulations that would be counter or weaker to previous regulations. Do those types of actions open the door for an individual or organization to bring a lawsuit citing the Green Amendment because it's a step back from the status quo? It's a diminishment of the existing environmental regulations.
Well, I look to sort of Montana and that pivotal case in which sort of the young petitioners ultimately were suing the state of Montana for having policies that did not consider climate change, and that ultimately was successful through the Montana Supreme Court. So, I mean, it's certainly something that I would expect, potentially groups to consider and look at. Again, I think the court, at least from the cases that we've had, have been really hesitant to say, hey, this creates actual substantive rights above and beyond what is there, right? It's really looking at, is there something so egregious that either no action was taken whatsoever, or is a clear sort of violation of the existing law? We haven't necessarily seen that. So it's certainly something to keep an eye on to see how that progresses.
Are any of these cases going to make it to New York's top court, the Court of Appeals? And is there any reason why we haven't had this heard by the state's top court already, since we're coming up on the 5th year of implementation?
Well, I think, generally the Court of Appeals, because it is this heady sort of constitutional issue, is looking to see how ultimately it plays out in some of the lower courts prior to sort of taking on that position. So it has a number of decisions to look at, not so different from the United States Supreme Court,
Sure.
right? They'll let things sort of play out in the various circuits. If there's disagreements among those circuits, then it becomes really ripe for their review. I think something similar is likely happening here. And ultimately, it also takes the litigant wanting to go to the Court of Appeals to make sort of that argument.
So they might be waiting for the best case to potentially bring, since they keep striking out at the
right.
mid-level appeals courts.
That's right. I think that's right.
Well, we've been speaking with Tom Berkman. He's a partner with the law firm of Hodgson Russ. Tom, thanks for visiting us in the studio. I really appreciate it.
No, I appreciate the time. Thanks.
Support for the Capitol Press Room is provided in part by the Lawsuit Reform Alliance of New York. Fraud and lawsuit abuse impact car insurance costs for New Yorkers. Reforms are being proposed to mitigate their impact. Information on these reforms is available at keepnewyorkaffordable.org.